early ingenuity and problem-solving skills can be seen throughout his time in office. And I'm just delighted to welcome Rebecca Oakes with us here this evening, and super, super excited that after tonight, I won't have to shy away from mentioning that Abraham Lincoln is the only president to have a patent, because I'll understand even more about it and can speak in more detail. So, Rebecca, thank you so much for joining us. We're delighted to have you here. I'm going to turn it over to you now.
Thank you so much, Callie, and thank you, Emma, and to the whole Lincoln's Cottage team. I am also delighted to be here today to share a little bit about this somewhat unknown but really fascinating piece of Lincoln's life. So today I'm going to talk a little bit about not only Lincoln's patent, but his connections to the intellectual property system more broadly, and what that can tell us not only about the time Lincoln lived, but also who he was, and even some of the skills that he took with him into the presidency. So I'm going to go ahead and share some slides. As Emma said, if you have any questions, please feel free to put them in the chat. I'd be delighted to answer them after the presentation. And we will go ahead and get started. So hopefully you all can see the opening slide here. If you can't, feel free to give me a shout. But so to get started, I will share with you all, as I was sharing with the staff at the cottage here, I went to school for history, specialized in the long Civil War era, and when I came to the patent office, I had no idea that Abraham Lincoln had once filed for and was granted a patent. So this was fascinating to me, and a lot of times I think it is seen as a little bit of a fun fact, if you will. Lincoln's the only US president with a patent, and it's not often that we get to delve into the story behind his patent in more detail. So I'm really excited to have the opportunity with you all, people who are interested in Lincoln's life and learning about different aspects of his experience. Really excited to delve into that with you all today. So to start off with, we are going to talk a little bit just a little bit about the foundations of the patent system in the U.S., particularly at Lincoln's time, so that you all have a good understanding of what it meant to apply for and receive a patent in the 1840s when Lincoln was operating. So first off, just a few basics, and I'm oversimplifying this a lot. My patent attorney colleagues could probably go into much more detail, but what is a patent? So a patent is a form of intellectual property protection, and specifically a patent gives inventors the exclusive rights to their inventions for a period of time. So in exchange for that, so basically that gives inventors control over who manufactures their invention, who can use it, and whether or not they want to kind of bring that invention to the public use. But in exchange for that exclusivity, the inventor agrees to disclose their invention. So anyone can go to that patent once it's granted, read the patent and see how it works. And this is basically to foster innovation. Once an invention is disclosed to the public, people can look at it and they can even think about ways to improve it. So they can't necessarily use that inventor's particular product without getting their permission, but they can kind of think about that next step, and that's what drives innovation forward. So today we have three different types of patents. Utility patents are the way something works, or a process, or a piece of machinery. A design patent is a protection for the way something looks. And a plant patent protects certain cultivars of plants that are kind of asexually produced, so produced with kind of the human hand, if you will, not naturally occurring. During Lincoln's time, only utility and design patents were something that could be issued by the patent office. Plant patents came a little later. To receive a patent in any of these categories, an invention must be new and novel, which means that it has to be something that hasn't been done before, or something that's not too similar to things that have been done before. And of course, the most famous inventions are world-changing technologies, like Thomas Edison's light bulb or Samuel Morse's telegraph machine. But the vast majority of patented inventors throughout history represent small incremental improvements over existing technology, and that is true of Lincoln's patent. These small improvements add up over time to change how we live and work. So I'm just offering a few kind of examples of patented technologies or items that you might recognize today. So we have the zipper. This was the last in a series of patents related to zipper technology that got us to the garment that we know today. The slinky. So again, something that we kind of use in our daily lives, but has kind of that underpinning of intellectual property protection. The Statue of Liberty received a design patent to protect its appearance. And Honeycrisp apples received a plant patent in the 1990s when they first hit the market. What this shows is that inventors can come from all walks of life. So engineers and scientists, certainly, but also furniture makers, hairstylists, caregivers, and even future presidents in the case of Abraham Lincoln. So to talk a little bit about Abraham Lincoln and the patent system as a whole, one patent that you may not recognize right at first glance is Abraham Lincoln's patent for a method of buoying vessels over shoals. And we'll go into some detail about what that patent did and why he felt the need to invent it. When we think of Lincoln today, we often think of his leadership during the Civil War, his soaring oration, or his experiences as a self-taught prairie lawyer. We don't often think of Lincoln as an inventor. His experience in innovation is a little less well known, but we can really learn a lot about Lincoln the man and the world he lived in by exploring his connections to patenting. Today, Lincoln remains the only US president to apply for and be granted a patent, and he likely had more hands-on experience with all aspects of the patent system than any US president in history. During his career as a lawyer, he legislated over 24 cases related to patent law. And he's now studied for his oratory skills, which patents was in the theme of innovation came up in many of his pre-presidential speeches. And finally, as president, Lincoln and his administration made significant and long-lasting changes to the patent system. So that's some of what we're going to explore today. Very briefly, just to go over some of the foundations of the patent system and some of how it relates to other US presidents. The patent system actually has its underpinnings in the US Constitution. So in Article 1, Section 8, Clause 8 of the Constitution, which is now known as the Intellectual Property Clause, the idea of securing for limited times the exclusive rights of discoveries to authors and inventors. So this covers both the patent system and the copyright system. This is actually the only personal freedom included in the body of the US Constitution, not including the Bill of Rights. So it was something very foundational to the nation. George Washington actually advocated for protection for inventors in his first address to Congress in 1790. Now we know it as the State of the Union Address. And because of that, the first Patent Act was passed later that year. And then following that first Patent Act in 1790, the first patent board was created. So it was composed of Secretary of State Thomas Jefferson, Secretary of War Henry Knox, and Attorney General Edmund Randolph, who began meeting at regular intervals to examine patents. So as you can imagine, Washington's cabinet was a little bit busy. They didn't necessarily have a lot of time to dedicate to this patent examination process. So only 3 years later, Congress decided to do away with the requirement that an invention be useful and important. That effectively meant that they didn't need to be examined, or not examined nearly as closely. Instead, applicants would receive a patent regardless of the invention's merits, even regardless of whether or not the invention was an improvement was novel, if they followed the directions and applied correctly. The US Patent Office itself was created in 1802, but it had such a small staff at the time that they weren't able to examine patents in a meaningful way. And for several decades in the early republic, this type of patent system continued. So patents from that time period, again, they're not necessarily new and novel. And because of that lack of examination, if someone followed the instructions and they paid the patent applicant fee, they were very likely to receive a patent. So today, these patents can tell us a lot about what was important to society at the time, but they don't necessarily tell us, or at least not all of them, can tell us what the cutting edge advances of that society were. These patents were actually not even numbered. So once the numbering system began, they kind of retroactively put a letter X on all of these early patents. And today we refer to them as the X patents. But many patents from this time period deal with infrastructural developments or ways to make daily life easier, particularly on the frontier. And that's something that we can kind of see thematically throughout Lincoln's life as well. Growing up on the early frontier, he was able to kind of identify ways to make his work easier and life easier for those around him. But by the time Lincoln did receive his patent, the patenting system was a little bit more stringent. So by 1836, a coalition of inventors, business leaders, and lawmakers who understood the need for further regulation advocated for legislation to do exactly that. And the Patent Act of 1836 was passed. This introduced a patent numbering system. It reintroduced that examination requirement that had been taken away. But they also staffed appropriately. They hired, for the first time, professional patent examiners whose job was dedicated to examining patents. They also established a library of what is called prior art, which allows patent examiners to go back and look at previous inventions, both patented and not patented, to see if the technology in front of them had ever been used before to similar effect. This piece of legislation, although it's been built on extensively over the years, remains the foundation for our modern intellectual property system. And this is the system in which Lincoln received his patent, as well as the legislation that he used when he was practicing patent law. So with that, a kind of a very brief explanation of the patent system, we turn to our main character for the evening, Abraham Lincoln. So born in, and much of this will probably be repeat for you all because I know you, are having an interest in Lincoln and study him. But born in 1809 in Kentucky, Lincoln spent his youth in Indiana. Both of those states were considered the frontier at the time. So places where kind of infrastructural development was still in the process of modernizing to that standard of the time. Lincoln received a basic education, but he was largely self-taught and he was very determined to do so. He was described as a child in non-flattering terms, as always, quote, reading, scribbling, writing, ciphering, and writing poetry. So he had a keen interest in not only learning, but advancing his own ideas from a very early age. Upon moving to Illinois in early adulthood, Lincoln first became a skilled surveyor. And his skill was actually sought out by many in his community. So he was establishing a reputation for himself and his excellence very early on. He was curious to both expand his knowledge and understand how the practical application of knowledge could be used to solve problems. Lincoln, throughout his life, was a voracious reader, and that included books on science and mathematics. And when he was a circuit lawyer, he purportedly actually would take the time to examine farm equipment when he found lodging in a family home. So from this, what we can tell is that he had a interest not only in kind of his practical knowledge, but also understanding how the practical application of that knowledge could be used to solve problems. As Lincoln began to establish himself, the Patent Office was also undergoing kind of these major changes, and that confluence of events led to him receiving his own patent. One of the problems that Lincoln looked to solve kind of in his pre-presidential career was something that was felt very keenly by his community at the time. Rivers were vital to movement of people and goods in the first half of the 19th century, particularly at the time what was considered the Western states, where road networks were just were not quite as good. This is the time period before railroads really became a major form of transportation. So rivers were really how people moved and shipped goods over long distances. Shallow rivers, however, presented kind of a unique challenge. So the Sangamon River, which was near New Salem, Illinois, where Lincoln lived and worked in his early adulthood, was one example where it could only feasibly be navigated by a flatboat, and sometimes in periods of kind of lower rain, that wouldn't even work. Lincoln experienced this firsthand in 1831 when he ran aground on a crude flatboat on a trip to New Orleans. Thinking quickly, Lincoln basically ordered the cargo removed from the boat so that the buoyancy of the boat increased. and he drilled a hole in the bow of the boat to let the water escape. He and his party were eventually able to make it to New Orleans, but that experience highlighted the challenges of river travel for even small vessels in the early 19th century. Decades later, Lincoln was returning home from his first session of Congress in 1848, and he witnessed a steamboat, so a much larger vessel called the Canada, run aground in the Detroit River. The crew had basically came up with a makeshift solution, just as Lincoln did 2 decades prior. They used barrels, boxes, planks, anything that they could get their hands on, and they pushed those under the sides of the boat to lift up the vessel until it cleared the sandbar it was stuck on. This experience, coupled with his earlier experience of having to do this himself, gave Lincoln an idea for a solution to this very seemingly common problem. And that resulted in Lincoln's invention and later his patent. So Lincoln's invention, which is entitled A Method for Buoying Vessels Over Shoals, basically relies on chambers on either side of the boat or ship that could be inflated with a system of shafts, ropes, and pulleys. Don't ask me how exactly this worked. I'm definitely not an engineer, but basically they would be deflated as a default state, and if the boat ran aground, they could be inflated kind of through this process. This would then allow the vessel to float over to a shoal. This was a major improvement over kind of this ad hoc process that Lincoln had both seen and experienced during his life, because the cargo did not need to be unloaded for it to work. So it saved time, and it standardized the process a bit so that the crew didn't have to worry about trying to kind of strike that balance or even using some of the cargo in order to get the ship unstuck. It also didn't harm the vessel, in contrast to his solution of drilling a hole in the bow of the flatboat that he'd originally kind of experienced this problem on. And finally, the chambers would contract to a very small place when not in use, which provided an unobtrusive solution to the problem of running afoul on these shoals. So Lincoln came up with this idea. He figured out how it was going to work, and then he decided that he wanted to pursue intellectual property protection for his invention in the form of a patent. And Lincoln's process for receiving that patent mirrors that of the process that many inventors go through. So first, inventions generally start with an idea, but an idea alone is not enough to receive a patent. Inventors need a tangible working invention. And furthermore, they need to clearly explain how it functions in their patent application. Now, patent applications are often very technical. They're often speaking to people who understand that field of invention very well. So for you and I and people who are not necessarily ship engineers, looking at Lincoln's patent doesn't necessarily give us a clear idea of how the invention worked. But Lincoln and other inventors like him need to be able to explain that invention to someone who understands the patent examiner in order to receive a patent. At the time Lincoln was applying for his patent models, which were miniaturized working examples of the invention, were also required by the patent office. And you can see this is actually Lincoln's patent model on the screen here. So you can see it's kind of this miniaturized version of a flatboat or a ship, and the items on the sides and then the kind of levers and pulleys around them, that is the method for buoying the vessels over the shoals. Lincoln created his patent model in the workshop of a Springfield mechanic named Walter Davis. So he kind of hands-on created his own patent model. And then when he returned to Washington, D.C. to pick up the next part of his term as a congressman, he consulted with a patent attorney named Z.C. Robbins in the capital city to basically figure out whether or not his invention was new and novel enough to patent. And that's the typical step an inventor would take. The vast majority of inventors employ a patent attorney to help with their application. Although I will say the vast majority of inventors are not also lawyers, whereas Lincoln did fall into that bucket. Robbins advised that the invention was patentable and filed the application on Lincoln's behalf on March 10th of 1849. His patent went on to be examined by a trained examiner at the patent office, and then it was granted on May 22nd, just over 2 months after it was filed. So despite the success, Lincoln never brought his product to market or made any money off of his invention. And that's because what happens next, that is really dependent, once you receive a patent, that's really dependent on the inventor themselves and whether or not they choose to or are able to successfully pursue commercialization of their product. So what can we learn from Lincoln's patent itself? So we can learn a few things about Lincoln, that he was creative, determined, and he was unafraid of trying new ways to solve problems. So he wasn't content to necessarily continue doing things the way that they've always been done, and he used his experiences to guide him. He learned quickly and he saw his projects through. So from watching the Canada run aground in Detroit to receiving his patent, that was a period of time of less than a year. So he definitely was able to, and this might have been something that he was working on already, but he's definitely able to kind of pick up skills like patent model making necessary to achieve his goals very quickly. He valued the expert opinions of others, even when he himself may have been able to do the work. So the example here is consulting a patent attorney when he was also a lawyer. The patent attorney had more specialized skill within that area, and although Lincoln likely could have learned it, he knew that consulting with this outside expert, was probably the best way to go. He wanted to make things better. So Lincoln, kind of throughout his career, you can see kind of in his oratory, his moves as president, that he is continually striving for progress. And this was the case with his patent and his invention as well. And more broadly, we can learn that a successful patent did not guarantee a commercially successful product. There was a lot of work ahead of inventors after being granted a patent, especially at this time, where inventors were often expected to take a personal role in marketing. Lincoln, who at the time was a practicing lawyer and a congressman, had other priorities, which tells us that Lincoln could prioritize. And that's something that he would have to do throughout his life, and particularly during his presidency when he was facing the largest crisis that America had ever faced in the form of the Civil War. So we mentioned that Lincoln at this point is a practicing lawyer, and he actually had some connections to the patent system while he was practicing law as well. So Lincoln practiced law for over 2 decades before being elected president, and the cases he took on were highly diverse. Some lawyers at the time did specialize, but a lot of lawyers, especially in an area where Lincoln was operating, so not in one of kind of the major coastal U.S. cities, took on cases as they came. And with Lincoln, he was able to kind of learn about a lot of various areas of the law in this way. A handful of these cases were related to patent law. So out of his 5,000 plus cases, a little over 24 related to patent law, and a few of those actually went to a full trial, but he definitely delved into patent law within his career. Patent law at the time was kind of seen as an obscure field within law, and is typically reserved for seasoned lawyers. And because of that, most of how he approached his practice, but also some of the common challenges with the patent system at the time. So the most common reason patents ended up in the court system was patent infringement. And that's still the most common reason that patents end up in the court system today. Basically, patent infringement meant that one party was arguing that someone was using their patented technology without their permission. So keep in mind, those patents mean that an inventor has an exclusive right to that technology for a period of time. Or someone is arguing that a patent never should have been granted in the first place because that invention already existed or was already common knowledge. And we have examples of both, and examples of things that are even a little bit more complicated than that when we look at Lincoln's experience as a lawyer. So there's a couple court cases that I want to highlight. The first two are kind of show some of the different aspects that Lincoln dealt with. And then the third case that we're going to highlight is the one that he's most famous for, which is a little bit ironic, as we'll see. But this first case, which is Parker v. Hoyt, Lincoln represented the defendant who was allegedly infringing on a patent for a water wheel. In his defense, Lincoln argued that the invention was based on common sense technology. So this idea that the patent shouldn't have been granted in the first place because people were already doing this process well before the patent was granted. In order to prove this, Lincoln actually took the time to explain the action of the water wheel to the jury very clearly, and he was basing this on his own experience working in a sawmill. Because he did this and because he had that experience to rely on, Lincoln was able to win the case, and the defendant was able to resume operations in addition to other people in mills facing a similar issue at this time. Another case is Edmonds versus Myers. This spoke to the confusion over the differences between utility and design patents at the time. So again, a utility patent is something that protects basically the way something works. So that includes patents like Lincoln's, which is a process or a mechanism or some type of machinery. A design patent protects the way something looks. So this patent, which you can see on your screen here, was issued to Alexander Edmonds for the ornamental design of a baby cradle. And this became the subject of 4 different court cases, all related to this one patent, because basically the plaintiffs, John and George Myers, purchased the rights to this patent from Edmonds. And when they did so, they did not understand that the patent only covered the design. It did not cover the way that the cradle was used. The Myerses claimed that Edmonds misrepresented the patent they purchased, he implied that it would cover the function of the cradle and not just the design. The plaintiffs retained Lincoln, so Edmonds retained Lincoln, the Myerses retained Lincoln, and they originally won the case. But they lost the appeal in the Illinois Supreme Court, basically on the grounds that they did not disclose the profits that they earned from the cradle, nor did they prove that any fraud had taken place. So this not only speaks to some of the confusion over the patent system at the time. Again, it's a system that's still growing, it's still evolving, and sometimes even the law isn't necessarily catching up. But it also shows that Lincoln did not win all of his cases. Sometimes he didn't necessarily have the strength in the case, or he didn't have the kind of experience necessary to successfully litigate it. And that leads us to the most famous patent case that Lincoln participated in, which was McCormick versus Manny. Lincoln actually did not make a significant contribution to the outcome of this case, but it had much wider implications for his professional career and even later on his presidency. McCormick and Manny were both patent holders, and they were actually competitors in the field of reaping machines. So McCormick, which is Cyrus McCormick, you might actually recognize that name. He's one of the more famous inventors from this time period. McCormick filed a patent infringement suit against Manny in 1854. Manny's representation retained Lincoln to make the case's closing argument. So he had different lawyers for, and this was common practice at the time as well, and still is today with law practices, but he had different lawyers working on different aspects of the case, and Lincoln was retained and offered $2,000 to make the case's closing argument. But that representation also simultaneously asked a very experienced lawyer named Edwin Stanton to do the same. So Lincoln and Stanton were both working on these closing arguments. Through a very complicated series of events, the trial actually had to be moved from Chicago to Cincinnati. And during the process of that move, the decision was made that Stanton would make the closing argument. But Lincoln still showed up to the trial. So even though he knew he wasn't expected to speak, he showed up. He provided his closing argument to the counsel in case it would be helpful to them. And he waited for an opportunity to potentially add his contributions to the case. But Stanton snubbed Lincoln throughout the trial. This was their first time meeting. He was not impressed with Lincoln's appearance. He was not impressed with his demeanor. And he actually, throughout the trial, referred to Lincoln as an ape. And he asked why he was brought from Illinois when he, quote, can do you no good, to the counsel that was in charge of the case. Despite this poor treatment, Lincoln was impressed by Stanton's work. So when Stanton actually gave that closing argument, Lincoln found that he was in fact the right person that Stanton was in fact the right person for the job, that he covered things in the case that Lincoln hadn't thought of or considered. And that experience impressed him. He remembered that even years later. Lincoln would, as I'm sure is no surprise to many of you, eventually work with Edwin Stanton again. Stanton was appointed as to Lincoln's presidential cabinet as the Secretary of War during his presidency. So this kind of process throughout Lincoln's career as a lawyer kind of shows how connected the patent system is to many of the things that he's experiencing, even beyond his own experience as an inventor. And that was something that he carried with him into his oration as well. Lincoln believed innovation was key to bettering the nation's economy. And between 1858 and 1860, he gave a series of lectures on science and innovation that exhibited these points many times over. The lecture series itself was an attempt to make money after his kind of famous but failed Senate campaign against Stephen Douglas. So he needed funds. Lecture series were very popular at the time. This kind of idea of betterment or self-help was very popular, and Lincoln thought that perhaps he could make some economic, a good economic decision by using his skills that he picked up as a lawyer on this speaker circuit. Many of his speeches had the theme that free labor and the innovative process contributed to the human condition. So the idea that being inventive meant that people's lives would get better. One quote exhibits this, that Lincoln stated, quote, "Man is not the only animal who labors, but he is the only one who improves his workmanship." Throughout his tour, he cited written speech as a key to promoting innovation, so the ability to write ideas down and distribute them throughout society. He also cited the printing press as something that accelerated human progress forward. And he also cited the patent system itself. Lincoln saw technological advancement as key not only to improving society, but key to something else that he was advocating for at the time, ending the institution of slavery. He felt that technological progress would render slavery needless, and it would result in free labor, which would then foster more technological progress in the future, allowing all to contribute to kind of this march of a society bettering itself. This was vitally important because at this point in time, enslaved inventors were actually barred from the patent system because of the precedential decision, Dred Scott versus Sanford, which dictated that the people of African descent were not considered citizens of the United States. And this is just one example of how slavery robbed the nation of its potential progress. Lincoln saw this and he spoke about it in his speeches with the understanding that not only did innovation have an economic advantage, it had a moral responsibility as well. And finally, we reached Lincoln's presidency. So he actually, fun fact, he actually litigated his final case that related to patent law in March of 1861, just weeks before he was inaugurated as president of the United States. So this is a very hardworking man. The Patent Office during Lincoln's presidency did face a decline in patenting because, of course, as we all know, Lincoln's presidency also meant the American Civil War. A lot of inventors were either serving the military, taking up other important duties, or actually had left the United States to align with the Confederacy, which had its own kind of attempt at a patent office at this time. So they were faced a decline in patent filings, which meant that they faced a decline in fees, which basically caused the Patent Office to spiral into a financial crisis that Congress then had to help them out of in the later years of the Civil War. But that was only one of many interruptions that the Patent Office had at the time. The office, which was housed in Washington, D.C. So the Patent Office, the building that we're talking about, is actually now the National Gallery of Arts of the Smithsonian Museum. So you can still visit this building today. It was used as barracks for soldiers from the First Rhode Island. And you can see a sketch of that here. The soldiers are kind of put up in these temporary barracks next to patent models. And then it was later used from late 1861 until early 1863 as a hospital with room for about 800 patients, most of those who were facing either illness, disease, or wounds from battlefields around in Northern Virginia, around Washington, D.C., and recovering from those wounds at the patent office. When the patients rested there, they also rested among patent models, much like the one that Lincoln himself had submitted 15 years prior. Some famous people walked through the door at this point. So Clara Barton, who was actually employed as a clerk at the patent office prior to the Civil War, then served as a nurse when the patent office was in use as a hospital. Walt Whitman, the famous American poet, also served as a nurse at the patent office. And Dr. Mary Walker, who is today remains the only woman to receive the Medal of Honor, also served providing medical aid to soldiers treated at the patent office. And then finally, later within this time period, the Patent Office was the site of Lincoln's second inaugural ball in March of 1865, after he was elected to his second term. The patent system during Lincoln's presidency also underwent some various changes. So during Lincoln's presidency, despite everything that was happening with the Civil War and all of the competing priorities Lincoln was facing, he and his administration still found some time to dedicate to the patent system. So the term of patent protection for utility patents was extended to 17 years during this administration. Today it's 20, so it kind of has steadily increased in the amount of time that an inventor has an exclusive right to patents over the years. He also increased the flexibility in the term for design patents. So inventors could choose whether they wanted their design patent to be issued for 3.5, 7, or 14 years. Lincoln appointed three people with the title examiners in chief, and their job was to hear appeals by inventors whose patents were rejected. And this was basically the first instance of recourse for inventors that were in this situation outside of the courts. And this is something that we continue to do to this day. Inventors can come to a specific office in the United States Patent and Trademark Office and plead their case for why their invention shouldn't have been rejected for a patent. He also encouraged the use of emerging technologies in the war effort. One example of which is the ironclad ship, the USS Monitor, which contained many various patented technologies at the time. Although Lincoln's contributions to the patent system as president were not as famous, and rightfully so, as wide sweeping as his indelible contributions to human freedom or reuniting the nation, again, he could prioritize, but they nonetheless showed his understanding of how innovation could bring about positive change. So in conclusion, Lincoln's firsthand experience, both as a patentee and as a lawyer practicing patent law, made him a president uniquely suited to understand the U.S. patent system. Growing up at a time of massive societal change, Lincoln recognized that innovation had the potential to make life better for all. And his experience inventing and litigating reveal his determination to solve challenging problems and his willingness to learn about new topics to do so. And those are characteristics that he took with him into his presidency. So I'll leave us with Lincoln's own words here, a quote from his second lecture on discoveries and innovation in 1859, when he wrote, "The patent system changed this, secured to the inventor for a limited time the exclusive use of his invention, and thereby added the fuel of interest to the fire of genius in the discovery and production of new and useful things." So that quote today is enshrined on the U.S. Department of Commerce's building in Washington, D.C., and is also on the medal that world-changing inventors receive when they're inducted into the National Inventors Hall of Fame. So Lincoln's legacy of invention continues even with our modern inventors when they apply for, receive, and eventually change the world with their patent. So that's all I have for you kind of formally. I'm happy to answer any questions at this point, and hopefully you've enjoyed learning a little bit about Lincoln's patent experience with me.
Thank you so much for that, Becky. That was awesome. Definitely answered a lot of my questions that I had about Lincoln's patent.
Mhm.
There were a couple of questions in the chat, so I can go ahead and read those. First question is from Sarah. She said, did Lincoln try to commercialize and fail, or did he not try? I think when you were talking about that a little bit.
Great question, Sarah. Yeah, so he, as far as we can tell, he didn't really try. So I think my kind of theory on this, he didn't necessarily write a lot about his patent or what he kind of thought about it, but my theory on this is basically that he had a lot going on. And as we all know, even if you're a very high performing person, even if you are very intelligent and driven like Lincoln, you can't do everything. And so he kind of serving in Congress and then his law practice really taking off. He probably just didn't have the time to try to commercialize.
Great. Sarah asked another question, which was, where did he give the science and technology lectures?
That is a good question. I'm not actually positive about that. So I could definitely look it up. And if you want to, I'll drop my email in the chat as well. So if you want to reach out to me via email, I can get that answer for you.
Awesome. Thank you. If anybody else has any questions, feel free to put them in the chat. Um, yeah, let's see. Oh, David says he gave some discoveries and invention lectures in Illinois.
That would make sense.
That would make a lot of sense. Yeah.
Thanks,
Awesome.
David. Mhm.
Um, Great. Yeah. I think we had another question about just sort of the characteristics of inventors and just sort of Lincoln's sort of just his creativity and thinking about inventors coming from going out and fixing things, or were they sort of already solving problems that were presented in front of them? You mentioned McCormick was a big inventor of his time. Was he like a farmer himself, or was he working in different areas?
Yeah, so I'm not quite sure on McCormick's background. I will say just kind of general thematically, a lot of inventors, they have some hands-on experience with, so McCormick and inventors like him who are kind of career inventors or invented a lot can kind of, they kind of differ from people like Lincoln, who it's funny to even put Lincoln in the same category, but people who have one or a couple patents who might have had an idea based on their personal experience, and then they kind of apply for and receive a patent based on that. So basically, there's some people who are career inventors who their drive, their career, their goal is to invent new things in various fields. But a lot of inventors like Lincoln, they have expertise in a certain area and they use that expertise to make that certain area better. So there's a lot of variation, but most inventors fall into the camp of Lincoln, not of Thomas Edison, for example, who created, definitely had specialization, but created in a lot of different areas.
Awesome. Thank you for answering that.
Mhm.
Lincoln was the only president with a patent, but didn't other presidents invent things like Thomas Jefferson? Somebody asked. Yeah.
Yeah, so Thomas Jefferson definitely invented. He never received a patent for those inventions. So it kind of, and that's really kind of speaks to the patenting process. Not all inventors receive patents. Not all inventors can receive patents, because sometimes those inventions aren't necessarily something that rises to the point of a patent, or they don't necessarily have the time, the desire, the money, et cetera, to go through patenting their inventions. So Lincoln does remain the only president who received a patent, but he's certainly not the only person to be a president to be innovative and to even contribute very distinctly with their innovation to society in ways beyond just their political careers.
I will also note that that question was asked by David Kent, who has a wonderful book called Fire of Genius, which is
Oh,
about this and
Mhm.
some of Lincoln's other scientific endeavors. So it's a wonderful book if for those of you who are looking for something innovative to read about Lincoln.
absolutely.
I have a question, and so sorry if you had said this already, but is Lincoln's patent still in use on vessels over shoals?
Not really. Not as far as I know. No.
Okay. Awesome. All right. If anybody else has any questions, you can continue to put those in the chat. What someone asked, can you tell us more about the invention? What was it made of?
That's a good question. And it's one that Lincoln did not answer. So he didn't
Okay.
actually specify what the actual like expanding buoyant material was made of. It probably canvas would be my best guess. But he did mention, rope, the pulley system, which would have been wood. So and I can actually send you all the link to the patent if you want to kind of delve into some of the technical language that's used in a patent. So I can pull that up real quickly for y'all. And put the link in the chat as well. Did the USPTO, I see this question, did the USPTO continue to function during the Civil War? It did. So it was stymied by both receiving fewer patent applications and also all of the disruption that was occurring in Washington, D.C. at the time, but it did continue to function during the war.
Awesome.
Feel free to put in other questions. I'm just pulling up that patent real quick for y'all.
Becky, you made such great mention, and this really, really struck me about all that the U.S. was robbed of in terms of invention by Black people because of slavery. Do you know what the first patent that was issued to a freed person was?
I do. So the first one we know of, I should say. So the USPTO does not and has never collected demographic data like race or gender. The first patentee that we can identify for certain was a Black man. That was issued a man named Thomas Jennings, and he was issued a patent for a method of dry scouring, which is basically a precursor to dry cleaning in 1821. So he lived in New York City. At that time, New York actually slavery was still legal in New York until 1827. He was a freedman. But and I kind of oversimplified a little bit just because it wasn't the focus of this presentation, but the kind of experience of both freed and enslaved Black inventors before the Civil War is very complicated. And the kind of precedential decision that was set by Dred Scott versus Sanford actually barred not only enslaved inventors but freedmen freed inventors from Black inventors from receiving a patent until the passage of the 14th Amendment in 1868. So fully barred people of African descent from the patent system for that period of time.
We have another question in the chat, which says, is it likely that patents will change a lot in the future?
So in terms of what is being patented, so patented technology, absolutely. So that is one of the fascinating things, at least in my opinion, that I find about looking through historic patents is that you can really tell what these leading technologies are at the time, what people are concerned with, and what problems they're trying to solve. And that's the case today as well. So, a lot of our patents are in the realms of computer technology or biomedical advances, things like that. So basically this kind of patent these patents are a really good kind of way for historians to kind of take a look at society and through that historic lens and see what's important to them. So whether or not the patent system will change a lot in the future, it will certainly change. Whether it changes a lot and how quickly that change happens is really going to depend on the inventors and the needs of society as we move forward. But I will say the patent system, although the laws necessarily haven't changed significantly in the kind of the kind of recent years, the way the patent system is being used, things are a lot more interconnected now. It's a lot easier for people from all across the globe to apply for a US patent. So that's already changing how we do things at the patent office. So absolutely, as society changes, the patent system will change with it.
Awesome. That's great. We have another question that citizenship was a prerequisite of getting a patent previously. That is not currently true. When did it change?
Yeah, so US citizenship initially was a prerequisite of getting a patent. That changed around the same time as the Patent Act of 1836 was passed, but citizenship of some nation was still a prerequisite. And so the reason that this was a particular issue for Black Americans at the time is because Dred Scott barred them from citizenship. They did not have citizenship of another nation, and therefore they couldn't attest to citizenship, whether it be US or otherwise, to receive a patent.
Awesome. If anybody else has any other questions, please put them in the chat. And we're approaching sort of the end of the session. If there's any last questions? Does your office do publications, or what is the output?
That's a great question. And I realized I forgot to share my last slide, which would have answered that. We do have a really great series that I'd like to, I'll leave you all with the link. So we have a series that every month we put out a new story on an inventor, either a historic inventor or a modern contemporary inventor or entrepreneur, called our Journeys of Innovation series. And so if you're looking for kind of some more in-depth delving into kind of this experience of an inventor or an entrepreneur, I definitely suggest that. There's the history website that I believe Emma had put in the chat right at the beginning of the presentation, and that's just a start. It's this position that I'm in is fairly new to the office, so we're still expanding a lot. And so there's going to be more and more content added to that website in the future. So definitely if you feel like bookmarking it, I encourage you all to do that. Maybe an article on Lincoln and his patent will appear at some point, and some other interesting aspects of the patent system. And then I would also encourage you all to follow us on social media. You can find us at USPTO on LinkedIn, Facebook, Twitter, X, or Instagram. And we share a lot about historic inventors on all of our social media platforms as well.
Awesome. Thank you so much, Becky. I think this is a great place to wrap up. Everyone saying great job, which is awesome. So thank you for that awesome presentation, and thank you for everybody attending and joining us tonight. I know there have been a couple of links sent in the chat for our programs. I resent the link for the USPTO history website that Becky was just talking about, so that should be sort of lower in the chat, and then a link to join Team Lincoln and become a member to have more early access and exclusive access to events like this. If you enjoyed this one as well, we do have another one coming up in August, talking about sort of the Civil War and how it revolutionized modern medicine. So stay tuned for that as well. But yeah, other than that, thank you everyone and have a great night.
Yes, thank you all. It was a pleasure speaking with you today.
And a recording of this will be posted on YouTube. I realized I forgot to say that. So.